Welcome to Jury Charge and Literary Practice. Let's get started with this jury charge. Ready? This case is about the principals who are accused of committing the crime. As I indicated, these persons have only been charged with committing the crime and are not determined to have committed the crime. In that regard, you have heard the testimony of the witnesses who have identified the principals. It is now your opportunity to decide whether the district attorney sustained the burden of proof or whether these individuals charged with the crime are not guilty of the crimes as charged. You have heard the testimony of not only these individuals, but of all the others who had evidence to present to the court. After hearing the evidence, it is up to you to decide how to vote. If you have any doubt as to the meaning of the law that I have presented to you today, as you try to reach your decision, you may ask the bailiff to deliver the questions that you may have to my chambers. I will be happy to answer any questions that you have. I will be in my chambers. When you have reached your decision, just let the bailiff know. He will then get me from my chambers. You will then be led by the bailiff back into the courtroom. You must keep in mind that you are not to be influenced by sympathy. You are not to be influenced by prejudice. You are not to be in any way influenced by the passion of any of the participants in the trial. As jurors, you must decide the questions of fact. You must also follow the law in the case. I will instruct you in the law that applies in this case, but you are to decide the questions of law. As I indicated, if you have any questions with regard to the law, you may ask the bailiff to take the questions to me. I will answer any questions that you have regarding the law. You must decide as to the facts in this case. There are several defendants. The defendants who are accused of wrongdoing are the principals. If you decide that one of these parties is guilty of the crime, you must decide that they all acted in the same capacity. There are not accomplices. These parties have been charged with the commission of the crime. All have been charged with the wrongdoing. All are here in court to determine if the evidence is such that the district attorney can prove that they committed this crime beyond a reasonable doubt. As indicated, the district attorney has the burden of proof. As you know, all have been accused of participating in the crime in the same capacity. All right. We have some new literary material here, and this is actually from a recent NCRA, the Journal of Court Reporting magazine. If you're interested, it's the January 2017 edition or magazine. And this article is on the writing is called Writing the Republican National Convention. So let's read a little bit of this. Here we go. In July, NCRA Vice President Sue Terry, RPR CRR, a freelancer in Springfield, Ohio, and NCRA Secretary Treasurer Debbie Dibble, RDR CRR CRC, a freelancer in Woodland, Utah, covered the Republican National Convention, RNC. The JCR interviewed them about the experience. How did you get this assignment? Debbie Dibble. Networking. I had developed a relationship and have worked with Sue Terry in the past, so she knew my skills, my personality, my willingness to do what is necessary, even at the last minute, and that I'm a team player. So when she got the call, she reached out to me. This is also, obviously, a very important client. That reputation piece is very important. Sue needed to know that the person she brought in was highly qualified for the assignment, both in skill and in comportment, and would represent her well, preserving her reputation with a valued client. Sue Terry. Alderson Reporting is an agency I've had a long-standing relationship with. I didn't hesitate to say yes when they called. As I said earlier, I knew it would be a difficult and challenging assignment, but there's also some comfort in working an assignment like this with people who know your reputation and you also know their expectations. What was your initial response to covering the Republican National Convention? DD. Without hesitation, the answer was yes, sheer excitement. When I got the call, I was walking out the door to catch a plane to Washington, D.C. for an event. I took my equipment, completed coordination on the plane, and ended up renting a car and driving straight to Cleveland. ST. No hesitation. I've always loved a challenging job, and I knew this would be a challenge. There's pride in realizing that by providing these transcripts, you're playing an important role for those who are shaping the future of our great nation. So we'll read more of that another time. Let's start this jury charge. And let's see, I'm taking a quick look in here, see if we have anything challenging. We have cross complaint. Corroborated. All right, let's get started. A suggestion in a question is not evidence. Only when it is adopted by the answer is a suggestion evidence. Standing alone, a question is not evidence. You must keep in mind that the cause of action in this case is, and that there is a cross-complaint. The instructions apply to the cross-complainant in the same way that they apply to the plaintiff and defendant. The fact that a corporation, business, or public entity is a party must not prejudice you in your decision. You must treat each as if you were dealing with a person. Each entity is a person in the eyes of the law. Each is entitled to the same fair and impartial consideration and to justice by the same legal standards. Any issues in this case, you must refrain from any discussion upon that subject. The fact that a person has or does not have insurance does not have an effect on the cause of action. In a short time, the bailiff will lead you into a room where you will conduct your discussions. At that time, you must follow the law that I have set forth here today. You must keep in mind what I have just told you. You must pay attention to what was said in the trial and determine the credibility of the witnesses. You have been presented with evidence by both attorneys. The plaintiff's attorney must show that the defendants acted in such a way not to avoid the accident. You must see whether the testimony and evidence presented at trial corroborated this view. As to the question of insurance, if the evidence shows that prior to the trial any party made a statement admitting fault or blame for the accident in question and mentioning insurance, you are not required to ignore any such admission. Okay. Now let's get back to some literary practice, and this is an article on wellness. And the section we're going to start with in the article is called Keep Your Mind Sharp. Ready? With court reporting, your focus has to be spot on. Capturing the spoken word takes concentration and determination, especially when dealing with fast-talking deponents or lawyers who speak at the same time. Whatever the case, it's important to keep your mind as sharp as possible. From what research shows, our brains like to be challenged. Start by doing puzzles and mental math, or learn a foreign language. Part of learning a language requires memorizing grammar rules and new vocabulary. This type of exercise, which is sometimes referred to as strengthening your mental muscle, can help improve memory and could also help to reduce the risk of age-related memory loss. Make more me time. Has it been a long time since you visited your best friend? Have you always wanted to learn how to play the guitar? If so, carve out some time to do the things you enjoy. If you can't escape for the weekend, set aside 30 minutes a day or one evening a week just for yourself. Take some time to unplug from your computers and steno machines just to rest and recharge. Reading a book, watching funny videos, taking a bath, or writing in a journal are perfect ways to unwind. Do activities you enjoy. Chances are it will improve your mood and help relieve some stress. Bottom line, treat yourself well. When we have back pain, get frequent headaches, or feel distracted, it could be our body trying to tell us something. Find moments to stretch, make time for yourself, eat right, exercise, and keep your mind sharp. Your entire being, and not just your reporter's hands, will thank you. That would be a good one to read back to yourself. Definitely food for thought. Okay. Let's read this jury charge. We have in here accomplices, accessory, acquittal, all right, here we go. You must decide whether the defendants are the accomplices that the principal said helped him commit the crime. You must then decide whether the principal had accomplices and whether the accomplices are the individuals named in this trial. You must determine whether these individuals acted alone or whether they acted with the help of the others who are named as defendants in this case. If these individuals did not act alone, you must decide whether they had assistance from others who helped before the crime was committed. If you find that there is not enough evidence in this regard, then you must move for an acquittal. If they assisted in the planning of a crime, then you must decide whether the individuals in court are those defendants. The individuals who assisted in the planning of the crime are known as the accessories before the fact. You must determine whether the accessories before the fact are the other defendants in this case. The accessories before the fact are also said to have helped in the commission of the crime, not by being present when the crime was committed, but by helping to plan the crime. If you find that these individuals, for which there is testimony indicating their involvement, are not guilty of this act, then you must move for an acquittal. You must understand that the principal who has admitted to the commission of the crime named these individuals as accessories. If these individuals were not present but helped in the commission of the crime, they are to be considered accessories before the fact. An accessory before the fact is not present when the crime is committed, but is still guilty of committing a crime. An accessory before the fact is never present when a crime is committed, but is still guilty. If these individuals helped in planning the crime, then you must find them guilty of the crime. You have heard the testimony of these three individuals and the testimony of the other witnesses. You must decide who is more credible. All right, it looks like that will conclude our literary and jury charge practice for today. Thank you.